All right, Jamie Cridge, Amanda Irvin, please activate your audio and videos for me. Thank you. All right, if you both raise your right hands for me. Right hands. Thank you. Swear the testimony in this case to be the truth, the whole truth, and nothing but the truth.
Do.
Thank you. Once again, I'll let the parties know I've read everything that you have submitted. So as I understand it, Ms. Irvin is the ex-wife of Ms. Cridge's current partner. And Ms. Irvin is a school teacher. And I believe you're still going by Irvin. Is that right, Ms. Irvin? Okay, thank you. And Ms. Irvin is currently a school teacher where Ms. Cridge's 9-year-old son goes to school. She indicates she was unaware of that until she found out subsequently that that was the case. And Ms. Cridge is concerned by Ms. Irvin's contacts specifically between the period of May 17 through 20, where Ms. Irvin was trying to set up a meeting with Ms. Cridge because Ms. Cridge, being a partner of Mr. Irvin, would be around Ms. Irvin's son, and she wanted to get to know Ms. Cridge a little bit in that regard. And then the conversation changed somewhat in the messages that were going back and forth, and Ms. Cridge made numerous requests to Ms. Irvin to stop contacting, and Ms. Irvin persisted for, looks like, a number of messages through that 4-day time period. Ms. Cridge, do you have anything else you want to add? Understanding I have read everything. Go ahead.
No new information.
Okay. Ms. Irvin, do you have anything else you would like to add?
I do, Your Honor. I'm going to be referring to some of the exhibits that you said you've read. The petition that was made by Ms. Cridge is based on worries that concerning behaviors may start, and her use of the word start is correct, as I have not participated in these behaviors. Her initial request was because I supposedly had called her, but as in Exhibit 2, the call log is between Ms. Cridge and my husband's Facebook accounts, and that there's a declaration that verifies that. I also state that I did not call her on the messages between her and I. I'd also like to highlight that Ms. Cridge didn't file this petition until 7 days after I was granted a temporary restraining order and emergency custody of my child with her boyfriend. Ms. Cridge suddenly had concerns a week after these orders were put into place by Family Court Commissioner Zinn. I'd also like to draw your attention to Exhibit 1, where on page 9, where I included these orders that I'm speaking of. I would also like Your Honor to be made aware that Ms. Cridge started the conversation when most of these messages took place, when asking me if I called her, when she clearly knew I did not, as you can see by the call log I provided to the court, where it was another individual. I already had a restraining order in place against Ms. Cridge's boyfriend a week prior to this filing. I believe that she's assisting her boyfriend in actions that could be considered abusive litigation for RCW 26.51.020 The reason I believe this is Ms. Cridge's boyfriend has entered declarations in family court proceedings referring to this order as if it's already finalized and is misconduct against a child. The protection order is predicated on a phone call that I did not make and a concern that someday I would stalk or harass a child I do not know, making it a concern of a potential future not based in current events or past. Mr. Irvin, Ms. Cridge's boyfriend, has been found to be an unsafe individual for not only my child, but 3 other children by another mother, and has a history of substance abuse and domestic violence per RCW
Okay,
26.
Ms. Irvin,
Yeah.
remember I said I've read everything that's been
Okay.
filed, so I'm familiar with pretty much everything you've told me so
Okay.
far.
So my concern is that she's stating that I'm going to do this, and the reason, the messages that you see took place in a matter of minutes. This wasn't over the course of 4 days. This was a matter of minutes. The reason why the last message took place is I was attempting to, my son was being withheld from me for 3 days against court orders by commissioners and the temporary order was stamped and filed. So I was in fear for my son's safety, and that was the heightened of my emotional time in that time. I did not threaten, harass, stalk Ms. Cridge. I'd never been to her house. I don't even know any information about her son until she filed this petition and included his name. Other than that, I didn't know, other than my son knowing his first name, didn't know his age, didn't know his grade, didn't know any of that. This has caused me substantial emotional and psychological distress during an already emotionally trying situation in the family courts. She's attempting to harm my career. She's called my workplace, emailed my workplace, even talked to my boss well before this order was even filed. I don't understand why that would be. She also served me in my workplace in front of my students. I don't know and have never met her child. When I first initially messaged her, my ex-husband had arranged a meeting and I was trying to be kind and extend some kindness. When she got mad about, my husband calling her at that point, I didn't even know he had. I was saying, I think he has, I believe this. I can't control another individual. I didn't do that. There's other personal matters at play here, of course, not between Ms. Cridge and I, but I just want to reiterate that I haven't participated in behaviors that would warrant this type of protection order. I have no prior court rulings or anything against me for such behaviors like this, nor would a reasonable person believe that I would do such behaviors to a child. I feel like a pretty intense accusation, given my history with children. And that's all I have to say.
All right. Looking at the timing issue, it looks like the request of Ms. Cridge was filed with this court on May 26th, and your order from Commissioner Noguera was ordered on the 5th of June, so subsequent to Ms. Cridge.
That's the extension of the order. The first initial order that was Exhibit 1 was filed on May 19th. Commissioner Noguera extended it because Mr. Irvin asked for a continuance. So that's order number 2.
Okay, thank you.
Mm-hmm. The timestamp is on Exhibit 1, Your Honor.
Yeah, I see that.
Your Honor, if I may add one more thing, I don't know if it's important to you. What was that?
Say, go ahead.
Okay. Also, one thing I forgot to mention that I thought was interesting is Mr. Irvin's lawyer reached out to me in regards to this case, attempting to get me to motion the court to remove evidence. And I found that interesting if they're not planning to use this order as some sort of retaliatory thing in the family court. I don't know why his lawyer would be reaching out to me, attempting to get me to motion this court to remove evidence. I found that interesting, and I thought you should be aware of that.
Okay, thank you. For my purposes, Mr. Irvin is not a party to this. I understand you believe that Ms. Cridge is filed this petition as part of a plan with Mr. Irvin, but I'm not going to consider that as what's going on here because he's not a party to this, and I don't see any other evidence other than your suspicion that that's the case. So that's not going to be enough for me to think that that's the basis of this. All right, so I think you've explained it, but I look on the messages that occur from 17 May through 20 May, and I see Ms. Irvin on at least, I think, 5 different occasions. You contact Ms. Cridge after Ms. Cridge has previously said, stop contacting me. So, and you give various reasons, and your messages in and of themselves aren't necessarily threatening, but a person does have a right to say, don't contact me. And yet you continue to persist. And you've explained it because you were emotional. You thought that Mr. Irvin was, inappropriately maintaining custody of your child, and that was Ms. Cridge's issue, and you wanted her to work on it, or you thought she was involved in assisting in that. But she had sent you numerous responses saying, stop contacting me. And I think on 5 different occasions, you would then contact her. So anything you want to tell me about your thought process there?
Well, I suppose my thought process there was she was engaging in conversation with me while then putting at the end of her message not to contact her. Not that I don't want to respect not contacting her. After those messages took place, I did block her. She blocked me. I think, when my child's being withheld, it was one of my worst emotional moments. That was my worst behavior, my most emotional moment. So I think it wasn't that I was attempting to disrespect her request. She kept engaging in conversation. Our first message took place. I never contacted her after that. Then she asked me, did I call her? And it started up the conversation again. So I think that's kind of what took place. Those 5 contacts that you're talking about, those were in a matter of minutes. It was all in that May 17th timeframe. There was one message that took place on May 20th, and that was in regards to my concerns for my son. So I think that once I, came down from my heights of emotions, of course, my own reasoning, blocked Ms. Cridge, and she's blocked me, and we don't need to have future contact. There's no reason to, especially during a time like this. But it was just a time of my heightened emotions is essentially why that happened. I didn't threaten, stalk, or harass her, though, which is what the grounds for this order are.
Thank you. And Ms. Courage, clear up for me, please. It was unclear to me whether you and Mr. Irvin reside together or reside separately.
He's not my fiance. We do reside together currently, and we're purchasing a house together. So, yeah. And I've had to take several days off of work. I work court hours, court security for Pierce County Sheriff's Department, and I have had to miss 3 days of work because of this. I wouldn't do that if I didn't feel threatened by her statements or harassed. She made some serious accusations against my fiance, and that was very alarming to hear at the time. So yeah, I don't have anything to do with her other cases that she's talking about, and I just want the protection of having the law involved, not letting her contact me in the future. I think I've been through enough with her accusations that I don't need anything farther from her.
Thank you. And Ms. Irvin, you and Mr. Irvin have one child in common, is that right?
Yes, we do.
Okay, and what's the current custodial situation there?
I have full custody of him right now due to Mr. Irvin engaging in misconduct.
Right. Yeah. That's the order that Commissioner Zinn and then Commissioner Noguera signed.
Yes.
Okay. And prior to that, it was shared custody?
Yes, and that was agreed upon by both of us prior to that, yeah.
Okay, and how did that work as far as exchange of custody?
We usually exchange at daycare during daycare hours, so we don't ever come in contact with one another generally.
Okay, so that's how the exchange had been.
Yeah.
Okay, thank you.
Mm-hmm.
I'm going to grant the request for the order, and the order is going to be modified from the temporary order, and I will explain that. The concern I have is the concern I raised in my question to Ms. Irvin about why, after being asked not to have contact on 5 different occasions, you continue that contact. In my mind, somebody has the right to say, enough, I don't want to hear anymore, and somebody who continues to persist is harassing that person by their persistence. So I find there's a legitimate basis for me to enter that order. So Ms. Irvin, you are to have no contact with Ms. Cridge. So she's asked that. I'm now telling you that. You're not to have any contact with her and not harm her in any way. That hasn't been an allegation, but contact has been the primary one. I'm going to do 2 things that are different from the temporary order. I'm not going to put any restriction on your ability to have contact with Colin. Now, I'm doing that because that hasn't been alleged. It's been a concern that Ms. Courage has raised, saying if she's going to contact me, she may contact my son inappropriately. I understand he is a student at the school where you teach, and that can be an issue. Ms. Courage does have the right to come back if she believes that you are actually doing something which hasn't been put before this court yet, which is having contact with Colin and talking to him about this incident or something else. But I'm not going to restrict your ability to act as a teacher in that school for all the students who are there. So it's a different approach. I don't want to restrict your ability to do your job, and I haven't seen any indication that you have been inappropriate with Ms. Cridge's son in any way. If that were to happen, then of course Ms. Cridge can come back and ask that there be a no contact order at that time with regards to her son. But for that purpose, I will not enter that order today. And then I also will not put a restriction on you staying away from Ms. Cridge's home, which I understand now is Mr. Irvin's home, because I know you and Mr. Irvin have a child in common. And I want to leave open the possibilities for Superior Court when they address the custodial issue as to how exchange of custody may happen if, in fact, Mr. Irvin is allowed to have any custodial time with your child. So even though I haven't put a restriction on you going to Ms. Cridge's house, Ms. Irvin, you were still under the order not to have any contact with Ms. Cridge. So I'm doing this mostly so Superior Court has enough flexibility in dealing with whatever custodial order they wish to enter, and so that we don't have conflicting orders. All right, this order will be in effect for 1 year from today's date. Ms. Cridge, if you want it renewed, you'll have to come back to court and ask for it to be renewed at that time.
Thank you, Your Honor.
All right, a copy of this order will be available in the electronic file. Both of you will have access to that. Thank you.
Thank you.